Welcome, everyone. We're thrilled that you could join us today for today's panel discussion. Before we start, we have a few housekeeping notes, but first I will deliver the land acknowledgement. We want to acknowledge and recognize that this country is a traditional territory and home of many diverse First Nation, Inuit, and Métis peoples. Some of the moderators and panelists in today's webinar are in Toronto, located on the territory of the Anishinaabe, Mississaugas, Chippewa, Wendat, and Haudenosaunee peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. One of the moderators is in Peterborough, located on the territory of the Anishinaabe and Huron-Wendat peoples. We acknowledge that Peterborough is covered by the Collins Purchase of 1785. We honor these peoples and all First Nations, Inuit, and Métis people for their important contributions to this land and to the fields of intellectual property, traditional knowledge, and cultural expression.
In terms of housekeeping, your audio has been muted to avoid background noise. You are invited to submit your anonymous questions using only the Q&A button on your screen. Please don't wait until near the end of the webinar to send in your questions, as we may run out of time to answer them. This webinar qualifies for 1 hour of Canadian CPD credits. For Ontario, 1 hour can be applied towards the 9 substantive hours of continuing professional development as required by the Law Society of Ontario. For other provinces, consider including this 1 hour course as a CPD learning activity in your mandatory annual continuing professional development plan as required by the Law Society. This webinar is being recorded, and the recording will be emailed to all registrants within a few days. Any feedback on this webinar or suggestions for future topics can be emailed to events@lexisnexis.ca. Next slide. I now have the honor of introducing one of our panelists, Andrew Shaughnessy, partner, Torys LLP. Andy's practice focuses on intellectual property litigation and dispute resolution, representing a wide variety of clients in complex patent and trademark infringement and related litigation. He's predominantly a patent litigator with a focus on life sciences and recent experience in the oil patch. He has decades of experience protecting the IP rights of clients and has deep knowledge and perspective on pharmaceutical patents. He has appeared before the Supreme Court of Canada, Federal Court of Canada, Federal Court of Appeal, Ontario Superior Court of Justice, and Court of Appeal for Ontario, as well as specialized tribunals such as the Trademark Opposition Board and the Patent Medicines Prices Review Board. Andy is very active in the legal community and is a well-known Canadian speaker, teacher, university instructor, and author in Canada. Welcome, Andy.
Next up, I'm going to introduce Sean Stevenson, who's counsel at Dentons in Toronto. Sean focuses his practice on international trade and sanctions, government contracts, investment arbitration, and public international law. He is a frequent advisor to C-suites, boards, private parties, and governments. In global trade matters, Sean is engaged in some of the most complex and, quote, once-in-a-generation, end quote, matters. His practice includes WTO law, free trade agreements, anti-dumping and countervailing duties, import and export controls, sanctions, and customs. He regularly advises and acts for private parties, and governments on the full panoply of international domestic trade law and policy. He has served as counsel in trade, sanctions, and investment matters before arbitral tribunals, federal boards, departments, ministries, the Canadian International Trade Tribunal, the Federal Court of Canada, and the Federal Court of Appeal. In all matters, he's known to use the full range of legal tools to create leverage for clients in discussions with regulators, disputes, investigations, and enforcement. Sean's track record of success includes extensive experience in investment treaty arbitration, including acting in multiple cases under the UNCTAD arbitration rules with respect to all phases of proceedings and complex disputes through the Americas and Europe. He has acted and advised on cases in NAFTA, CAFTA-DR, CPTPP, and bilateral investment treaties in a large number of sectors. He's also acted in commercial arbitrations under the ICDR arbitration rules. Welcome, Sean. Next up, I'm going to introduce my co-moderator. Marcelo Sarkis is principal and patent agent at Prima RP. He is a professional engineer, as well as a registered patent agent in both Canada and the United States, and the founder of Prima IP. He's also a registered service provider with key innovation funding programs, including IP Ontario, Elevate IP, which is federal, and Accelerate IP, which serves startups in BC, the Yukon, the Northwest Territories, and Nunavut. With over 30 years of experience, including involvement in landmark pharmaceutical patent litigation, Marcelo advises startups, SEMEs, and multinational corporations with the protection, management, and enforcement of their intellectual assets. His expertise spans diverse industries such as mining, automotive, including EVs, pharmaceuticals, and medical devices. As a licensed professional engineer in Ontario, he is widely regarded for his ability to align deep technical knowledge with strategic IP planning, both in Canada and internationally through his extensive professional network.
And I have the honor of introducing my co-moderator, Lorraine Fleck, LexisNexis author, editor, and principal trademark agent, Fleck Innovation Law. Lorraine is the general editor of LexisNexis Canada's Internet and Technology in Canada newsletter, and a chapter contributor to both editions of Social Media and Law Forms and Precedents. As an Ontario lawyer and Canadian registered trademark agent, she advises businesses on advertising and marketing, artificial intelligence, risk management, and information technology, intellectual property, privacy, and adjacent regulatory matters impacting brand and corporate reputation on a domestic and international scale. Having over 20 years experience in intellectual property and technology law, Lorraine also helps companies protect their brands and negotiate tech-related agreements. A frequent speaker and published author, Lorraine is known for translating complex legal issues into practical strategies using a commercially and reputation-sensitive approach.
Thanks, Marcelo. We'd also like to thank LexisNexis Canada for sponsoring this webinar, and especially Frank Griggs, who's a content development associate, and Monica Sorensen, who's the senior marketing manager, for their help in the promotion and organization of this event.
Next slide. So this is our agenda for today: introductions, poll questions, panel discussion, audience questions, and panel conclusion. Before starting our panel discussion, we would like to hear from you, the audience. And so therefore we have two poll questions here on the screen.
So
all of you who click no to number one will have to click yes at the end of this session, I suspect.
Okay, so we're going to start with our first question, and that's going to be me asking Sean. So is this the beginning or the end of this trade dispute? I think it's a question that many people want to know the answer to, right? So they can plan.
Well, thanks very much, Lorraine and Marcelo, for having me here, as well as LexisNexis for sponsoring. A pleasure to be here with everyone this afternoon. Beginning or the end? I can say that as a tired trade lawyer, I hope we're near the end. But on a more considered opinion, I don't think we are, and I don't think we're close to the end. You know, just the common sense approach is Trump has only been he's only been in office for just over 4 months. So we are really still within the very nascent era of Trump's presidency, despite the fact that it might not necessarily seem so, because we have been thinking about tariffs in a very intense way, at least in Canada, for the last 4 months. So are we at the beginning or the end? I have to say we're closer to the beginning than the end, and I can unpack that a little bit. To just level set with everyone right now, Canada, and speaking primarily towards tariffs and how they are applied to Canada. There's obviously a much broader conversation on global tariffs that the U.S. has imposed, but for the purposes today, I'll be focusing on specifically Canadian related tariffs. But to level set, Canada is subject to various classes of tariffs that have been imposed by the U.S. Of course, there was the sort of the first wave, what we call the IEEPA or fentanyl tariffs that were imposed March 4th. There was somewhat of an exception that was rolled out on March 7th, where CUSMA originating goods can enter the United States on a tariff-free basis. In addition to sort of the broad-based tariffs that we have under IEEPA, we have sectoral tariffs that have been imposed or that are likely to be imposed coming into the future. So with the tariffs we know at this point, of course, there's the auto tariffs which have had a significant impact on Canada. There's steel and aluminum derivative products, which are global in nature, but obviously apply to Canada. Those might be augmented as of June 4th. So we're sort of waiting and seeing if Trump is going to go through with his threats that he made over the weekend as to whether those will rise from 25 to 50%. And then there's a slew of tariffs that have been, or potentially tariffs that have been launched. There are investigations in progress, and these cover a range of different goods, from pharmaceuticals to semiconductors to lumber. Through social media posts, President Trump has also mused that he might somehow put a tariff on the film or entertainment industry. So, films or movies that are made outside of the United States. We haven't had anything concrete on that yet, but, less to say there's multitudes of tariffs that have been imposed, and, we are sort of still in the throes of those investigations where more tariffs are likely to be imposed. So again, we're still more at the beginning than we are at the end of these things. From an IP specific perspective, tariffs haven't been targeted directly at IP. We contrast what happened in Trump 1, particularly vis-a-vis China, where, forced technology transfers were called out and were subject to the first trade agreement between China and the US there. We haven't seen similar call-outs on a broad-based scale for tariffs that have been imposed as of yet. So right now, tariffs have been impacted on an indirect basis. So if you have a good, for example, that is Canadian origin, is going to be crossing into to the United States, the value of the IP in that good can be obviously included in the value that will be subject to tariffs. So an indirect aspect there, but we haven't seen any direct implications for intellectual property yet, in terms of just we're targeting your IP because it's Canadian IP as such. It's really been a broad-based tariff that is imposed on goods and goods themselves. So more or less physical items that are crossing the border. Tariffs that are coming down the line or likely to come down the line, for example, in pharmaceuticals and semiconductors, might have more of an intellectual property nexus there, but again, the tariffs are likely to be on the goods themselves rather than the IP behind the goods, if we're going to make somewhat that distinction. So, tariffs certainly have an IP connection, but we haven't yet seen, a full-fledged tariff on intellectual property or broad-based, services. What will be the end? For Canada, this was always, and Mexico, frankly, it was always fairly straightforward. We do have the CUSMA review, which was always slated to occur in 2026. So we're sort of moving towards that. The end of the tariffs are likely to be some sort of negotiated deal between Canada and the US, or potentially Canada, US, Mexico in a sort of revised CUSMA deal. So we're moving towards that. That was always going to occur. The United States has tried to use tariffs as leverage. In the words of Secretary of Commerce Scott Bessent, they use it as strategic uncertainty. So will tariffs be imposed perpetually? Will they be increased? You don't really know, and you can't get a good read of the Trump administration. So they're using them to sort of try to get the best deal they can out of multiple countries, of course Canada included. In terms of the renegotiation, that's going to start as early as this coming fall, and it's going to move all the way into 2026. From an IP perspective, one thing that consistently has been been noted by the United States, or at least in the U.S. view, is the Canada's Canada's domestic law on IP and its trade implications. Through multiple years, there are 301 reports have been released. Through multiple years, the U.S. has consistently taken the view that there are Canadian IP issues that are trade issues. So we look at the most recent report, which was released in late April. Again, we have those similar concerns based on, for example, piracy and, for example, counterfeiting of goods. Obviously have IP relations. Those could potentially take on a heightened level of importance given what we're dealing with right now. But the negotiations will occur in sort of regular course. And generally speaking, I think the U.S. has demarcated key issues in those negotiations through those sectoral tariffs. So through the auto tariffs, through the steel tariffs, lumber, pharma, semiconductors. Those are going to be sort of the core issues that we're dealing with. Other things like IP are more of a consistent trade irritant. They might take on heightened importance in those negotiations, but they're certainly something that has been around for quite some time. One last point on are we at the end or not? We might have had an end or potential end to some tariffs last week, where we had U.S. court decisions specifically on IEEPA, on the IEEPA related tariffs. So for Canada, that's the fentanyl tariffs. For the rest of the globe, that is the reciprocal tariffs on quote unquote Liberation Day. What we did have last week was a very important decision coming out of the U.S. Court of International Trade. That court essentially nullified those tariffs. That decision has been appealed, and a stay on that decision has been granted by the Court of Appeal. So as of right now, the sort of status quo, tariffs are still being collected. US CBP still has a mandate to collect those tariffs, and we will see sort of where that litigation goes. But it's certainly not the end because we have one court decision. Maybe positive from the perspective of countries facing tariffs, that the US court system is working and they'll work their way up, likely to the Supreme Court. But that the litigation does not constitute an end to the tariffs. I think it's just a continuation, and we might see tariffs even transform into different forms. So I'll stop my comments right there and pass the microphone back.
Thanks, Sean.
So we do have a question, Lorraine, in the Q&A for Sean. So Sean, you're not done yet. Does strategic uncertainty actually work in negotiation of trade deals?
Look, it obviously has created, or at least created, a heightened sense of urgency in terms of we need to get a deal done, and many countries have sort of taken that approach by at least discussing the issues and putting those issues high up on their agendas in terms of discussions or trade talks with the United States. To date, we haven't really seen that bear fruit. We have the UK who made an agreement with the US. That agreement is fairly narrow in scope, and broadly speaking, most UK goods are still subject to a 10% tariff. We've seen other countries like, for example, Japan, really put themselves up there at the front of the queue in terms of discussing with the United States. From their experience, they sort of backed off and said, when you're ready to discuss what you want from us, we're happy to talk, but we're just not going to go in and make you an offer when we don't know what your clear priorities are. So, it's definitely causing uncertainty. The strategic uncertainty, at least in my view, might actually be backfiring on the US administration. I think we're seeing more and more people move out of the United States and say, we can work around. We've seen really novel things. For example, the UK and India have now a trade agreement, or at least an agreement in principle. We've seen the ASEAN region say we're gonna actually negotiate a trade agreement amongst ourselves or make our trade agreement better. And here in Canada, we have also seen, of course, the heightened level of interprovincial trade. So we've seen a lot of places saying, hey, maybe we can just trade better amongst ourselves rather than with the United States. I think, time will tell in terms of strategic uncertainty. The US is obviously an important economy, but it might actually not have the effect that the US administration is intending.
Great, thank you. The next question is for Andy. Andy, are there tools in Canadian IP law that can be deployed as a countermeasure to all of this?
So let's set the scenario. Canada finds some lever or some tool that it has in its IP warehouse to use as a retaliatory measure. Are there any available, and what might that look like? If I can restate the question, Marcelo. And why don't we kick it off? In January of this year, Professor Richard Gold at McGill had suggested in an op-ed in a national paper that, quote, Canada must respond with all economic weapons at its disposal, a key armament of which is its intellectual property, such as patents. And in the article, he said boldly that Canada has the right, under its both domestic law and under international law, to effectively suspend patent rights held by U.S. companies, particularly in key sectors such as pharma and IP and AI, rather, and he called those out. And that was quite a bold statement at the time that he made it. And I think that Richard, if you asked him today, he'd admit to as much. In fact, I've asked Richard to come and speak at my Patently Absurd webinar in a couple of weeks so we can discuss this further. I think what Richard was trying to do was say, look, we should look to the world of IP because we need to have some levers to throw or drag out of our arsenal or out of our quiver in this tariff war. So what was Richard talking about in this article? He was referring to Section 19 of the Patent Act. What's that? Well, that's a provision that allows the Commissioner of Patents to authorize the use of an invention by a government, in the Canadian government in this case. The US has one of these provisions in their patent statutes as well, and they actually use it. They use it in relation to things like major public works and defense items. As I said, they've used it. I'm going to come back to this, but before leaving the point, I should say that Canada has never used their Section 19. So Section 19, also known as a step-in or a march-in or a walk-in right, is allowed for the government to say, we need that invention for some reason. So let's look at the features of Section 19. It has to be a government, can't be passed on to a commercial trader, can't be used by a commercial trader. So it's for the government for its own purpose. The purpose, the period, and the terms, including the remuneration that you pay to the patentee, have to be specified. The patentee has to be notified. And of course, the patentee has recourse to the federal court to review governmental action, and as well as to the commissioner. And so let me just give you this little tidbit. The commissioner may, on application by the patentee, terminate the authorization if the commissioner is satisfied that the circumstances that led to the granting of the authorization have ceased to exist and are unlikely to recur, subject to such conditions, etc. And so on. It gets boring after that. So basically, the commissioner, there has to be a reason for it. It's got to be stated. And what does Richard Gold say about the reason? Well, he says that the tariff war is a national emergency. So if you read a little further in the statute, it says that the commissioner may not authorize the use of a patent invention unless the applicant establishes, that's the government, that it has made efforts to obtain from the patentee on reasonable commercial terms and conditions the authority to use the patent invention, i.e. the government's got to knock on the door and ask for a license. But that caveat has a kicker. You don't need to ask for a license in cases of national emergency or extreme urgency, or where the use for which the authorization sought is non-commercial. And Richard Gold's argument is that the tariff war, national emergency, the government should use these march-in rights. I wasn't a fan of this when I heard about it, and I'm still not a fan for two reasons. One, we've never used it. We've never used this provision, and the United States has. So why would we use a march-in right with somebody who could turn around to use a march-in right against us and our Canadian patentees in the States? And I said when I was interviewed by the press around these articles that a U.S. patent in the hands of a Canadian company is far more valuable than a Canadian patent in the hands of a U.S. company. Like, I'm not a trade lawyer, but in my view, it's better to go tit for tat on tariffs as opposed to pulling on a lever that the U.S. administration could then deploy against us. So that's reason number one. Reason number two, what does Section 19 do? Nothing, in my view. If an American company doesn't want to come to Canada, if it's want to hold back its innovation or its products or services because it doesn't want to enter Canada for either most favored nation pricing or for some tariff reason, and there's a demand in Canada that's not being met by a patentee, the Patent Act has another provision to release those inventions. That's Section 65 of our Patent Act. And so we've got that road covered, and I don't think that the government would march in. It doesn't put the invention in the hands of a commercial trader. I don't know what it does. It just seems to be something that would just it's like a bee sting in the eye. You don't know why the bee stung in the eye, but it hurts like hell. And I just don't see it happening. I don't think Section 19 is a tool, and I've been pretty clear on that. And I don't see another tool, Marcelo, to come back to the question. Are there IP tools? I'm not so sure. I think there are tariff tools and trade tools, but not IP.
Okay, thank you, Andy. Now back to Sean. Given the instability being created in some markets, are companies, especially startups, starting to see Canada as a more reliable hub or springboard into North America?
Yeah, it's a great question, and I think, frankly, a question that more and more people are at least starting to think about. Given what's happening in the U.S. right now, and I think the key word in your question is instability. Of course, we are all sort of witnessing this in various facets of our life. The instability that the U.S. administration is causing vis-a-vis its trade policy, and frankly, what may be something or a position that the United States takes on a go forward basis. What we haven't seen is significant pushback by Democrats on the trade policy. We haven't seen significant voices come out and say, in a unified manner, we are 100% opposed to what is going on in the U.S. trade policy world. So it sort of leaves us with the question of, well, will there be an actual change if there is a change in administration in 3-4 years? That is still sort of up in the air, so to speak. And I think a lot of people are looking at that and saying, well, there could be a change, or we could be in a new sort of paradigm in terms of trade policy and U.S. industrial policy, where tariffs might be the norm, where we might not have sort of that non-discrimination, sort of key trade elements in our overall relationship with the United States, not only Canada, but the rest of the world. So I think people are starting to think about whether or not Canada could be an alternative to the United States for, as a landing pad. But the uncertainty is certainly a driver, and a driver of many things, including potential inflation and a potential recession as well. So what we're seeing right now is generally, and I think this was reflected in the poll that we had before, is a wait and see approach. I think there was 57% of people saying, we're monitoring the situation, but we don't want to make any rash actions because we don't actually know what the bottom is or where things will settle. And I think, settling is really for Canada a 2026 item where we have some sort of renegotiated CUSMA agreement, and people can say, we're going to take some solace in this renegotiation and say this is how we're going to go forward on a couple for the next couple of years. So most people taking wait and see. I would say there is one caveat where we are in a position of flux and change, and with flux and change can come opportunities. So we are seeing some people saying, maybe there is an opportunity, for example, in Canada, given that we're seeing so much change and potential for change in internal trade. Maybe we see an avenue to sort of, have an opportunity in Canada, given the changes that are coming down the line. Maybe we'll use Canada there. We're also seeing, people say, well, trading relationships are strengthening between different countries, whether it's, for example, Canada and the EU and military procurement and that type of IP. We're seeing those large scale announcements and saying, well, maybe Canada would be a good foothold in North America for example, for European companies. So there is opportunity there. So I think most people are taking a wait and see, but there are some first movers, I would say, when you can see a clear opportunity or, an opportunity that is reasonable to come down the line. And I think that's, one of the silver linings in all of this is there are opportunities. I know we're all trying to protect businesses from the implications of tariffs and changing U.S. trade policy. But in that change, there is, of course, room for growth, room for opportunity. The last point I'll make here is that, on a broad, long-term trend, I think what we do see and what we will see is a change in trade flows, where trade flows will be moving around the United States, and trade flows to the United States will change. So, from a Canadian perspective, we are seeing those initial announcements of, strengthening, particularly with Europe, but I think we're going to go see it on the other side of the country as well. From the West Coast to Asia and Asia Pacific. trade flows will change, and that might be an opportunity for Canada as well. If we can put the right mix of confidence and policy in place, particularly from the IP perspective.
Thank you, Sean, for that. So the next question is for Andy. Are clients adjusting their IP filing strategies in response to the ongoing tariff tensions? So are we seeing a slowdown, a redirection to other markets, or just a wait and see approach?
So this question took a little bit of digging for me on the weekend. I mean, anecdotally, I can tell you from the client base that the wait and see approach seems to be the general approach, which is consistent with the poll question, what Sean has just said. I'm an IP litigator, right? So I do enforcement, and I can tell you that my market does well in good markets. When the market is good, people want to protect their exclusivity. When the market is bad, people want to protect their exclusivity and get IP. Transitional markets are usually pretty tough for my business. And I think that that's where we're finding ourselves when we're in the sort of the world of wait and see. We're in a transitional market. So that's the overview comment. So let me start. Again, the question is, are clients adjusting their IP filing strategies in response to ongoing tariff tensions? Are we seeing a slowdown or a redirection of the markets or a wait and see approach? I think it's wait and see, but let me unpack this. And let me start by addressing what I think the impacts will be based on my clients and our clients and our client base. In the United States, we do expect domestic industries to experience some short-term protectionism from the tariffs in the United States. However, obviously, retaliatory tariffs in Canada are going to harm their exports to Canada. And I suspect that over time, that's going to lead to a complex environment for IP strategy in Canada. In Canada and Mexico, these are the CUSMA partners. These countries, I think, will also see shifts in trade dynamics. At least that's what we're hearing from the client base. And we're getting lots of questions about IP considerations for companies seeking to operate across the borders. And so people looking, okay, in those markets that I'm going to operate, am I protected with IP laws? Outside of North America, EU exporters into Canada facing tariffs are going to seek to strengthen IP protections in their alternative markets, in addition to Canada and the United States, that are going to look elsewhere. Some may invest in local production facilities to bypass traders. That's a big lift, right? That's a big cost, and that's going to shift capital from IP and IP protection and patent policy to bricks and mortar. And for Asia, countries like Japan and China, they may accelerate efforts to innovate and protect their own domestic industries. They've got strong markets there, potentially leading to an increase in local patent filings. At least that's what we're hearing out of Japan. And a focus on self-reliance and critical technologies and perhaps some in-licensing opportunities. And I should start this discussion with the proviso that I'm the patent enforcement guy. And I may be the wrong person to ask, maybe Sean's the right person to ask, but you did ask me, so a few things I've learned. Two truisms. Number one, tariffs are counterproductive to IP. That's what the commentators say. That's what the research shows. And two, IP is important to combating tariffs. Those two truisms seem to be at counter purposes. Sounds a little bit confusing, so let me see if I can unpack this. And I tried to do it with some data and then some commentary. First, the data. First, in 1930, during the onset of the Great Depression, the United States enacted a statute called the Smoot-Hawley Tariff Act. And I just wanted to read that because I like the name. The Smoot-Hawley Tariff Act raised U.S. tariffs on about 20,000 imported goods aimed at protecting American industries. And that move led to retaliatory tariffs from numerous countries around the world, resulting in significant contraction of trade. What was the impact on global trade? It declined by roughly 67% between 1929 and 1934. Impact on intellectual property? While the economic downturn of the Great Depression and the reduced international collaboration led to a decline in patent filings as companies prioritized immediate survival over innovation. It kind of seems like what we're going through now with this wait and see approach. That's data point number one. Data point number two, 1980s, 50 years forward. The U.S. was facing significant trade imbalances with Japan, particularly in the automotive and electronic sectors, and in response, the U.S. imposed heavy tariffs and sought voluntary export restraints from Japan. What was the impact on trade? Japanese companies responded by establishing manufacturing plants in the U.S. to circumvent the tariffs. Impact on IP? Well, the establishment of Japanese manufacturing facilities in the US led to increased patent filings by Japanese firms seeking to protect their innovations in the American market. Third data point, 2018, 2019. The US imposed tariffs on Chinese goods, citing unfair trade practices and intellectual property theft. And in this period of time, we saw escalating tariffs between the two nations. What was the impact on trade? Bilateral trade between US and China decreased, leading to shifts in global supply chains as companies sought to mitigate tariff impact. So this is what Sean talked about. People are just going to try and work around the problem, work around the US. What was the impact on IP? The trade war prompted discussions on strengthening IP protections and led to shifts in patent filings, with some companies diversifying their IP portfolios to other jurisdictions. So again, what we're seeing is IP is flowing with the products to the markets where they want to manufacture. That's the third data point. What's the fourth data point? Sadly, there has been a 10% decrease in Canada in patent applications filed in Canada by applicants with Canadian addresses. Sorry, I said that's a long way. 10% decrease in Canadian applicants. It's kind of 6% for all filers, but the trend around the world is the same. The number of filings is down. And that's true at the USPTO and other patent offices in Europe as well. And I think this is an unfortunate data point, and I think honestly to remain viable, Canadian businesses will need to reverse these trends and change their views on intellectual property and worldwide as well. So that's the data. We've got 4 data clusters. I'm not a prof in economics. I don't speak either official language, so you take what you get on a Tuesday morning with Andy Shaughnessy, but that's the data. Tariffs bad, IP needed. That's the takeaway, but don't worry, that's not just me. I've got some commentary as well. In an article published in the European Economic Review in 2022, some researchers examined tariffs and IP, and they came up with some interesting conclusions. They looked at this from a slightly different lens than the question, but I'm going to get into the article. The researchers showed that, quote, international patent policy coordination via national treatment is desirable only if tariff barriers between countries are sufficiently low. So let me stop there. National treatment refers to the clauses in most trade agreements, which calls for member countries to offer foreign firms the same level of patent protection that they provide for their domestic firms. National treatment is as a result of decades of trade negotiations. So CUSMA, TRIPS, all of these trade negotiations meant to harmonize IP around the world. And what these researchers say is really is that in order for that to work, national treatment to take place, you got to have tariffs low. If countries are free to impose their optimal tariffs, the researchers said, so if they can do whatever the hell they want, requiring national treatment and patent protection unambiguously lowers world welfare. Their words, not mine. So if you have a sort of a tit-for-tat tariff war and you've got national treatment, then it doesn't help that we have harmonization on IP because the world welfare is going the wrong way. So constraining tariffs is the path forward for restoring international coordination over patent protection. What does this mean? Tariffs breed protectionism, which engenders lack of national treatment, which means that each country's domestic laws are going to be in line with each country's domestic agenda, which means we're going to be on the US TR 301 list for years to come, et cetera. And so, which means that you have to do a lot more work making sure that your key patents are protecting you in the key markets in which you want to enter. It's interesting, the authors give us this detail. They say that their study provides a potential rationale for the historical sequencing of policy reforms observed in the global trading system. Multilateral rules on IP were adopted only after decades of trade negotiations had succeeded in substantially reducing global tariffs. And if I'm reading that correctly, we've arrived at this balanced international IP system because of the reduction of tariffs we saw in the last decade. Put another way, these commentators want to see trade liberalization, and they see that as a prerequisite for maintaining this balanced harmony in IP treatment. And that's the path forward to a better road forward. So at the end of the day, when we have high tariffs, that whole system is shaken. And I think for that reason, coming back to the question, I think that's why most clients are taking a wait and see approach. I'd like to suggest, though, that the smart money is making sure that you have an IP strategy for the markets that you want to get into. That's what we saw from the data points. And that's tough because ramping up your IP strategy when for the last few years we've reduced the number of filings, that's going to be costly. And it isn't rocket science. If you're putting money into IP, you need to take it from somewhere else, and that likely is going to come from innovation. It's going to come from research, especially in the climate where you've got higher costs because of a tariff war that's going on. Tariffs are not drivers of innovation. Experts have long voiced concerns over how tariffs can stymie innovation in this way. And they increase the costs of essential components you might need for your research and all the rest of that stuff. But more than that, it really does put on patent departments the need to be more vigilant in figuring out what the IP strategy is in the markets where you want to go. So let me see if I can short circuit this without going too much longer. It's almost like you need to hope for the best, which is wait and see, but you've got to prepare for the worst, which is diverting resources from where you should be putting it, which is in research and development. So hopefully that's some justification for why I say I think we've got a wait and see approach. But hopefully people are looking very critically at their markets, especially if Sean says this is just the beginning of the war and we've got a ways to go.
Thank you for that, Andy. Follow-up question. Are there tools to help kickstart an IP program?
Well, there are. This is most patent practitioners. I'm not a patent prosecutor per se. I'm a litigator, but I am aware of many patent toolboxes that are available. Programs like Elevate IP can help startups. Elevate IP programming is delivered for startups in Ontario, Manitoba, and Saskatchewan, in partnerships with Invest Ottawa, North Forge, Communitech. Again, the long discussed patent box regime is one potential bright spot on the horizon. These offer tax benefits and incentives for a company to develop and commercialize IP in Canada. They're out there, they're publicly available. There's a long list, and I can just go through them. The person to ask is Marcelo because he's an advisor in this area, but there's Venture Ontario, their Life Sciences Innovation Fund, seed and pre-seed co-investment funds to help commercialize Ontario IP biotech. There's an Ontario Research Fund. There's the Early Research Awards and Ontario Research Fund. There's Critical Technologies Initiatives. There's a Digitalization Competence Center. There's Futurepreneur Canada. That's a $2 million fund. Small business enterprise centers are throughout the world. So there's lots of little opportunities to do a little bit of digging. A little bit of professional help can get you guided in the right direction, but a lot of self-help can also help you because you're in a competitive mode to fight for some of these grant funds. But I mean, we're talking about 50 million, 90 million, 40 million, 15 million, 207 million, 75 million. There's money out there to help kickstart IP.
Thank you for that, Andy. So I think we're going to go on to our Q&A. Marcelo, do you want to kick it off? We have a couple of questions.
Sure, we have a few. So this is a question for Sean. Is software as a service more like a product in the way IP is treated under current or contemplated tariff regimes?
Yeah. And we've had, particularly in the early stages of the trade war, a multitude of clients ask us about SaaS and SaaS products and whether SaaS is necessarily caught. Generally speaking, SaaS products are not caught, and that's similar with IP. There's not one SaaS is not a generally speaking a good, so a physical good crossing the border. So not caught because there's really no trade infrastructure there. And IP would follow sort of a similar vein. As I said before, IP itself has not been targeted. So that's an issue. Could it be targeted though? And that's a question that has come up of do we need to be worried, or are we just going to be staying within the worlds of goods? In my view, it would be a pretty marked departure if we started going after things, or if the US started going after things that aren't goods. If they start moving into, well, particularly in SaaS as services, generally speaking, the US runs a pretty significant services surplus with most of the world. The US is generally speaking a service economy. So those arguments that they had sort of before of, well, we're running a trade deficit mostly doesn't apply, particularly doesn't apply to Canada. Could they get there though somehow? We started contemplating that when Trump, over a weekend, I believe, put out a tweet on, tariffing or potentially putting some sort of tax on, foreign produced films. And the initial reaction for everyone was, well, you can't do that, Mr. President. That's just not possible. But if you take a step back and you say, look, the US government actually does employ some very interesting, intelligent, creative people, there are potential ways. It might not be the tariff that you are used to seeing, but for the film and sort of film entertainment industry, there are various ways that they could put a tax in place that would have the same effect as a tariff. Now, it would be a tax that might require Congress actually moving forward with a bill rather than just presidential authority. But similar, you could think of a similar element or a similar way forward for IP. So could they do it? Let's not let's not pretend that the US government hasn't been ambitious and creative in the way that they're going to do things. So could it get there? We could see a very interesting application. I think that would be a pretty significant escalation, however, and I don't think we're necessarily there yet. So the short answer would be yes, treated very much like SaaS, and generally speaking, not a direct target of tariffs.
Thank you, Sean.
Okay, next question is for Andy. How can the use of standards such as ISO standards and their domestic equivalents protect intellectual property in the middle of the trade war, and to what extent?
So the answer is that standards can be used as a defense, a tactic for tariffs, against tariffs. But I think it's important that standards can't be used to protect IP, and this requires a little bit of unpacking. So let me start the answer with the very popular Dennis Crouch. He publishes a very popular patent legal blog in the United States, and he sort of touched on this topic in April after President Trump took the initiative to increase tariffs on imports. Dennis Crouch says major trading partners such as the European Union, China, and others considered countermeasures that went beyond the tit-for-tat tariff regime. And what he was referring to there are non-tariff measures, or NTMs, and they can include a variety of impediments to reducing access to markets without imposing a customs duty. And these non-tariff measures, they include quotas, import licenses, export restrictions. For instance, right now China is restricting the export of rare earth metals, which the United States really wants, and that's driving the president in the United States. Got to be careful because I'm sitting in the US right now, driving him crazy. And other non-tariff measures can be imports, licenses, and standards that regulate product quality or safety. So these have been around since, people wore short pants, meaning a long time, in my case. And they've been deployed over the past several decades, as we talked about in some of the 4 examples. Dennis Crouch now says the world has changed, and so he thinks that these non-tariff measures are going to come to the fore, and standards being one of them. So can standards work to affect change? Yes, when it comes to tariff, I think, although I'd really defer to Sean on this because he's the trade lawyer. But let me explain why they don't really assist in terms of assisting IP. The standards don't increase the economic good in the whole like the IP system does, and that requires me to explain. There's a tension that exists between IP and standards, and that's because the objectives that they try to achieve are cross purposes. The main purpose with IP is to differentiate products, to differentiate services, differentiate the businesses that produce and sell them, allow them to have a period of exclusivity to give the public a choice. And that period of exclusivity is an incentive, and that incentive brings about innovation and differentiation, and it's great for market growth. That's been shown time and time again by the research and the commentators. On the other hand, the objective of standards is to harmonize harmonized products, harmonized services, harmonized processes. Put slightly differently, IP encourages differentiation, whereas standards encourage generalization and uniform obedience. And I say obedience because standards impinge on the operation of the free market. They reduce the various possible ways of manufacturing and or producing or offering services, and so they reduce consumer choices. So standards may be justified by economic efficiency, cost reduction, quality improvement, protectionism, or even in retaliation to tariffs, but they nevertheless impose constraints on the ability of businesses and consumers to choose in a free market. To achieve choice in the free market, that's the IP system. Intellectual property is just the opposite of a tariff. And I'm not an economist, but I've heard it described that IP is the regulation of a market that encourages differentiation, standards regulate products, and stifles differentiation. And the result is overall market losses to consumers. So standards IP, not the same, slightly different. I probably botched trying to explain why that is. And if everything of what I said sounds like a tautology, it probably is. But that's my answer, Lorraine. Good question. Thank you.
Thank you, Andy, for that explanation. And we have a question now in the Q&A as well that Marcelo is going to pitch.
Yes. So we have a question here, I think directed to Andy. What are the potential risks and consequences for Canada if it were to suspend US IP protections?
So let me just unpack this. So what are the consequences for Canada if Canada were to suspend, and let's call it protection for US IP rights holders, just so we have it, because all of the IP protections would be in the United States. I think the risks are twofold. Number one, if Canada were to do anything other than offer equal treatment or national treatment to US filers, I think you're going to expect that it's going to be tit for tat across the border, especially with an administration that has used some of the patent tools before. Even so, for instance, even if Section 19 doesn't apply, shouldn't apply, has never been applied, and we use it to somehow damage a US patentee, I think we should expect to see it applied south of the border. What's the downside? That market in the United States is huge, and Canadian traders are small. And any cessation of their market exclusivity is going to hurt them immensely. Remember, IP is only as good as you've got your market exclusivity. And if in a very short window, a Canadian trader loses exclusivity in the US market, they're done. There's just no incentive to continue to trying a business. So I hate to say it, but it's sort of the David and Goliath scenario. And I don't see that our David Canada has a good stone to throw at the giant in this case. Great question. I think that's the risk. There are other things that the U.S. could do, and they've done in the past when our domestic laws are out of line. They file challenges at the WTO, and eventually we're required to get our domestic law in line. There have been a number of instances in that. That takes years, and I'm worried about the daily basis or the monthly basis of a Canadian trader to get into that market. Great question. Thank you for it.
Thank you, Andy. Just checking to see if there are any other questions. I don't see any. How are we for time, Lorraine? Are we
We have 5 minutes.
okay?
Can I ask a question of Sean while we have him? Because Sean, we're at the advent now of and this isn't scripted, so I apologize. I'll buy you lunch when I'm back in Toronto. We're at the advent of a new government. So, like, how is the new government now dealing with, like, what tools does it need to put together over the next little while to get ready to then sit down and deal with trade, not only with the United States, but with Europe and Japan, etc.? Like, it's a big ask of our new administration.
Yeah, certainly. I guess we'll deal with this in two parts. One, vis-a-vis US, two, vis-a-vis our other trade partners. I'll start with our other trade partners because that's an easier ask. Canada is incredibly well situated based on our other trade agreements. Not only do we have the United States, which is a significant trading partner, but we have already established, it's there, locked in agreements with the UK, the EU, as well as a multitude of Asia Pacific countries. So we have a well established base. And, as we all know, those agreements took years and years and years to negotiate, but they're there. They're enforced. They're, being operated on. So what we need to do, to further leverage those types of agreements is sustained engagement. And that is, generally speaking, one thing that Canada has not been particularly good at. And you'll, if you go back and read reports from, the Canadian Chamber of Commerce, you'll sort of see that consistent commentary of, we've got these great trade agreements. That's a phenomenal initiative by government, but we can't stop at the agreements themselves. We need sustained engagement in other markets where we're pushing Canadian businesses, or we're assisting Canadian businesses as much as possible to go sell our goods in whatever it is, if it's Europe or if it's in Asia Pacific. So consistent trade missions. I think you're seeing, initial announcements from the Carney government on, for example, particularly defense, on like Rearm Europe, where government can really be a leader for Canadian businesses and really assist them in getting a foothold there. So in terms of our other trading partners, is consistent engagement, consistent engagement in different markets, consistent Canadian trade missions to other markets. If you're looking to expand, those are the things that we have. We have on the trade side seen a few programs, both federal and provincial, that will assist people in doing so. So if you're interested in, looking at different export markets, now's a great time to do it, because there's, much like you said, for IP, there is money out there right now for diversifying your trading market. Vis-a-vis the US, I mean, we have been thinking about this obsessively in the trade world for probably 2 years now. The initial trade consultation for the CUSMA renegotiation started last summer. So before really any of this blew up, before we knew Trump was going to be president, we were already preparing. The Canadian government was sending out questionnaires to businesses, trying to get a sense of what we would like to tinker with in the CUSMA renegotiation. I think we need a little bit more of that, given the heightened different situation right now, and particularly for those demarcated industries. So, steel, aluminum, pharma, semiconductors, those are going to be really demarcation points in the negotiation. So we need to be very clear on what we're willing to do vis-a-vis those industries, because that's going to be pretty significant. Otherwise, the good thing is for the government, they have all of the tools at play. One thing that we're going to be watching closely is when there's additional tariffs potentially imposed on Canada, what do we do? So there was the question of, could we suspend all of the US IP in Canada? I mean, potentially there might be a legal basis to do so. Is it a good idea? I mean, as Andy said, any reaction that Canada has to US tariffs might elicit a further counter reaction that could be counterproductive to the overall, relationship and and the moving toward the goal that we actually want is, stability, certainty in an agreement, whatever form that takes on trade and potentially trade and security. So the tools are largely speaking there. I think, a broader consultation on what we're doing would be helpful at this point throughout the summer as we move towards the CUSMA renegotiation. And I know from many of our clients and associations, that process is underway, where we're asking ourselves, we're going to go into negotiation. Potentially the whole entirety of the agreement can be on the table. What would we want to tinker with? What do we think the US is going to be asking from us? And, how do we get to a place where we can, get some sort of agreement? So, the good news is we've got the tools. We're just sort of working on it, operationalizing those things right now, so we can move to the negotiation where the government is, well informed, and obviously we'll have to make certain hard decisions, but those decisions will nevertheless be made by them.
Great answer. Thank you, Sean, for enlightening us. I see that it's 2:00, so we are up. So we're going to wrap it up. I'd like to thank our panelists, Andy and Sean, for doing a great job in today's webinar, just clarifying this whole trade dispute for us and putting some insight and perspective for us. So thank you.
And thank you also to our attendees and our sponsor, LexisNexis Canada. I found today's session, I learned a lot. And I always have this motto, I do not want to be the smartest person in the room, because then I'm in the wrong room. And so it's been an absolute pleasure having Sean and Andy to work together on this webinar.
Thank you.
Thank you for
And we
having
do
me.
hope, we hope everyone found this webinar useful. Our contact information is on the last slide. I don't know if you want to just put that up, Lorraine, the last slide, just real
Sure.
quick, if anyone wants to take a screenshot. There's our contact information there. So again, thanks everyone, and we hope you enjoy the rest of your day.